Hello, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about city bylaws. Cases that should have gone to the Supreme Court of Canada, but didn't. The Supreme Court of Canada ruled in 1973 that it is not a defense to a zoning bylaw case that the city has never enforced the bylaw before. But the Supreme Court of Canada made that decision specifically about zoning bylaws. Now, in our society, we see so many other cases that deal with the city's enforcement or non-enforcement of bylaws, particularly in cities across this country that use their municipal powers to allow cannabis dispensaries to operate in the gray sphere. Prior to legalization, those dispensaries got city permits or operated without city permits, and the city did nothing to enforce them. Since cannabis legalization, we've seen raids by cities and shutdown of dispensaries by cities, including huge fines and potential jail time for people continuing to operate cannabis dispensaries, even though cannabis is now legal in Canada. A similar situation happened in a case in Montreal involving a numbered corporation which was running a business as a massage parlor. The massage parlor was offering erotic massage services, and despite the fact that the city had taken no action to enforce the erotic massage services bylaw that prevented the business from carrying on in this way, for years the city did nothing, and then finally took action to shut this business down. At trial, the business tried to argue that they couldn't enforce the bylaw after years of ignoring the fact that this was going on while they were well aware of it. It's a doctrine in law known as estoppel. The Supreme Court of Canada had the opportunity in this case to clarify whether its 1973 judgment also applies to other types of city bylaws or whether it only relates to issues with respect to zoning. And because of the significant implications that this type of case is having on people who are trying to operate cannabis businesses within a municipal system under legalization of cannabis in Canada, it would have been an important opportunity for the Supreme Court of Canada to lay the groundwork for how ultimately these cases are going to be enforced by the courts. But instead, we're left with a lot of circumstances where the Supreme Court of Canada's last pronouncements on the issue are 40 or 50 years old and may not any longer be good law or may not even be applicable to the circumstances. The Supreme Court of Canada missed an opportunity to get ahead of an issue here and to set the stage for challenges that we all know are coming to various bylaw powers throughout municipalities throughout this country. Unfortunately, now we're going to have to wait and see if any of the cannabis-related cases make their way to the Supreme Court of Canada before we know whether this issue will be revisited again. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos, and like, subscribe, and share with your friends.